More than half of America's largest corporations are legally incorporated in a state most of them never set foot in. It's not an accident. Delaware didn't become the corporate capital of the world by chance. It engineered itself into that role, and the mechanism that made it possible is still running, largely invisible, reshaping how wealth moves through the American economy. To understand why Delaware matters, you first need to see what corporations were running from. In the late 1800s, incorporation meant something genuinely burdensome. States taxed corporations aggressively. They restricted what businesses could own, how they could operate, even where they could do business across state lines. New Jersey saw an opportunity first. In 1888, it loosened its incorporation laws, let companies incorporate there without actually being there, charged lower fees, imposed minimal restrictions. Corporations flooded in. The state collected revenue. Everyone won, or so it seemed. Then Delaware moved. Around 1899, it studied what New Jersey had done and built something better. Cheaper incorporation fees, even looser rules. But here's the crucial part. Delaware created a separate court system just for corporate disputes. This wasn't just bureaucratic convenience. It meant corporations got predictable, specialized judges who understood business law intimately. No jury trials, no local political pressure, just contract law applied consistently, year after year. By 1913, New Jersey realized it had lost. Other states were copying Delaware's model. The advantage had shifted. New Jersey tried to compete but couldn't match Delaware's institutional depth. By mid-century, Delaware had become the default choice for corporate incorporation across America. But incorporation is just the beginning. The real mechanism involves something called the Delaware General Corporation Law, a statute so permissive it reads almost like a blank check. Directors get broad latitude to act. Shareholders have limited power to challenge decisions. Disclosure requirements are minimal. Consider a concrete example: executive compensation. A Delaware corporation can award its CEO stock options worth millions without a shareholder vote. Try that in another state, and you'll face litigation, regulatory scrutiny, even criminal charges in some cases. Delaware, it's standard practice. Then there's the subsidiary structure. A Delaware corporation can hold multiple layers of subsidiaries, some in Delaware, some in other states, some offshore. Each layer adds opacity. Ownership chains become nearly impossible to trace. Liability gets compartmentalized. Risk gets isolated. This matters for tax strategy. A Delaware holding company can own operating subsidiaries in high-tax states or countries. Profits flow upward as management fees, licensing payments, or interest on internal loans. The operating company's taxable income shrinks. The holding company's income is taxed elsewhere, or nowhere, if structured correctly. The system has feedback loops built in. As more corporations incorporate in Delaware, more tax revenue flows to Delaware. That revenue funds better courts, better legal infrastructure, more sophisticated statutory innovation. Other states can't match it. The advantage compounds. Today, roughly 1.6 million corporations are incorporated in Delaware. That includes more than 65% of Fortune 500 companies. Most of them have no physical presence there. Some don't even have a real office, just a registered agent's address, a mailbox essentially. The economic consequence is enormous. Delaware collects roughly 20% of its state budget from corporate franchise taxes and filing fees. For a state with fewer than 1 million residents, that's a remarkable advantage. Other states lose tax revenue. Delaware gains leverage. But there's a second layer to this story. Delaware secrecy isn't just about incorporation law, it's about ownership secrecy. Corporations can be owned by other corporations, which are owned by trusts, which are managed by anonymous agents. The beneficial owner might never appear in any public record. This became especially valuable after 2008. As regulators worldwide pushed for transparency in financial flows, Delaware's opacity became a feature, not a bug. Money laundering, sanctions evasion, tax avoidance, all of it flows through Delaware corporate structures because the trails are deliberately hard to follow. Federal law has tried to close some gaps. The Corporate Transparency Act, passed in 2020, requires disclosure of beneficial owners to financial institutions. But enforcement is weak, and exemptions are broad. Delaware's advantage persists because the system is designed to be resilient to reform. So here's the answer to our opening question. Delaware became America's corporate secrecy capital because it first recognized that states compete for incorporation revenue, then engineered a legal system so sophisticated and flexible that it became the default choice. Once that network effect started, it fed itself. Better courts attracted better lawyers. Better lawyers refined the law further. Competitors couldn't catch up. It's a system that works exactly as designed, which is precisely the problem. The architects didn't intend to hide criminal activity or enable sanctions evasion. They intended to attract capital and revenue. But when you build a machine that rewards opacity, opacity is what you'll get. This video is for educational and informational purposes only and is not financial advice. Always do your own research. If you want to understand how wealth moves invisibly through legal systems, subscribe. We break down one structural mechanism of modern finance every week. This video is for educational and informational purposes only and is not financial advice. Always do your own research.